Well, thank you very much. I appreciate you all coming, and I'm especially grateful for a lot of the legislators that are here today. This has been a common fight that we've been involved in over the last few years, so I appreciate it very much. Yesterday, my office, General Paxton from Texas, and a bipartisan group of 29 states and state agencies obtained a historic stay from the U.S. Supreme Court to freeze the implementation of President Obama's illegal and unprecedented Clean Power Plan. This is a monumental victory for West Virginia, the country, and the rule of law. But most importantly, this Supreme Court decision is a win for coal miners and their families here in the Mountain State. For years, I've fought Obama administration overreach, and I've looked to stop these illegal EPA regulations that violate the rule of law and compromise our way of life here in West Virginia. Now, we've had success in those efforts. We've prevailed against the Obama administration in obtaining a stay of the Waters of the United States rule. We had a big victory in the Michigan v. EPA case, something that served as a key case law precedent for winning the stay yesterday. But yesterday's decision to stay the President's power plan is truly historic. And I hope its impact will begin to reverberate across the state. From the southern coal fields to north-central West Virginia to the capital region to metropolitan areas across the country that rely on clean, affordable coal, this is an important decision. I'm hopeful that we're going to begin to stop hemorrhaging jobs here in the state of West Virginia, and we're going to send a message that the rule of law will be upheld in the United States. Now, with this ruling, West Virginia has an opportunity to begin its comeback and stop some of the bleeding that we've experienced from this administration. West Virginia will save taxpayer dollars as a result of this decision, and real families will benefit. It's also my hope that the American public will begin to learn just how far-reaching the Obama administration's power plan really is. Let's be clear. This rule represents a radical transformation of American energy policy and will have a sweeping impact on the American way of life. The EPA is seeking to transform itself from being an environmental regulator into a central energy planning authority for the states. Fortunately, that's not legal under the Clean Air Act, the case law precedent, and the Constitution. And that's arguably why we obtained the stay yesterday from the U.S. Supreme Court. Now, in just a minute, I'm going to turn over the mic to General Ken Paxton from Texas, who's been a terrific co-leader of this effort. But before I do that, I want to make a couple of very important points. First, this stay is a strong signal that the Supreme Court has serious concerns about the legality of the power plan. To grant a stay, a Supreme Court has to conclude that the challengers are likely to succeed. Don't let the administration or other people try to spin you on this point. Now, we have no reason to believe that the Supreme Court did not examine our stay request with the traditional elements that you look at. The likelihood of success on the merits, a finding of irreparable harm, and that the balance of equities favor a stay. And in fact, as the EPA argued just a few days ago, the Supreme Court granting of a stay of a regulation before any other court ruled on it is truly unprecedented. To our knowledge, this type of stay has never happened before. We doubt that the U.S. Supreme Court would have taken such an unprecedented action if they didn't have serious legal concerns about the power plan. And I would note that the EPA was very specific about these points. They said, quote, "The relief that the applicants request would be extraordinary and unprecedented." They further added, quote, "It would be extraordinary and apparently unprecedented for this court to stay an agency rule that has not been reviewed by any court." So don't let them spin out of this. This is a very significant win in this case. Now, the stay of the power plan also means a couple other critical things. One, the EPA has no power to force states to prepare to implement the power plan. The Supreme Court's decision to stay the EPA's hand means that states and utilities are not required to continue following the illegal power plan. There is no, I repeat, there is no legal process to institute formal state plan submissions. The requirements for the states to prepare for the stay are now stayed. The need to change state laws and reconfigure state energy portfolios under an illegal rule, they are stayed as well. The Supreme Court has sent a message to all of the states. Put down your pencils, because the EPA has no authority to issue and force this illegal rule down your throats. All states should heed this very important message today. Now, I'd like to thank the broad bipartisan coalition that has come together to fight this illegal rule. We have 29 states in a bipartisan matter, and I'd like to really thank my colleagues across the aisle and every AG in the country that's been involved in this effort. We have the labor unions, the United Mine Workers, the Boilermakers, IBEW. We have the Chamber, businesses from across the country. We have coal operators. We have utilities. We have consumer groups. And we have concerned citizens. We all worked as a team in order to achieve this very important result. I'd also like to take a moment to recognize some other people who really made this happen. This was a team effort. My Solicitor General, Elbert Lynn, deserves an enormous amount of credit for the outstanding legal work that he performed. He is one of the top constitutional lawyers in this country, and West Virginia should be very proud that he works in this office. Thank you, Elbert. In addition, my former general counsel, Misha Saintlin, was tireless in this project. He did a lot of very heavy lifting and really deserves a lot of credit. And I want to thank Zach Ritchie. Zach has been very aggressive working on this as one of our assistant attorneys general. He has a very bright future in the Mountain State. And of course, there have been many other people in our office and across the country working in Texas, Oklahoma. A lot of the state AG offices participated. This is about a team. And we were able to pull together, and through that coalition effort, we were able to prevail. Now, let me end by saying that this stay is not the end of our fight. While today, West Virginia gets a real ray of hope in this ruling, it's my intent to keep pushing every single day and begin to see if we can put some people back to work. That's absolutely critical. Real people are hurting, and that has to change. We have to go down to the southern coal fields. We have to look in people's eyes and say, there's been a lot of devastation over the last few years, but there are real people fighting back against this administration's overreach, and we're going to keep going. Now, we know that the devastation has already occurred in West Virginia. Things are not going to change overnight, but we have an opportunity to have a comeback now. This is the decision we've been waiting for, and now we get to move forward and try to put people back to work. So I'm appreciative with the opportunity to come here today. I'd like to thank all the legislators. I'd like to thank the Coal Association for coming. And what we're going to do now is we're going to turn over to General Paxton, who's going to provide some comments as well. Then we're going to take some questions, and then we're going to give some of the legislators and some others an opportunity to speak. General Paxton?
Well, good morning from Austin, Texas. This is Texas Attorney General Ken Paxton. I'd like to start by thanking Attorney General Morissey and all the other attorney generals in this effort whose hard work and leadership have really made a difference in the lives of Americans today. Yesterday, the U.S. Supreme Court put a stop to the EPA's attempt to impose its new power rules into the lives of Americans coast to coast. Simply put, the EPA had placed the livelihoods of far too many people on the line when it attempted to impose these misguided rules on the country, and thanks to the court's action, we can all rest a little more securely today. The power rule they tried to put in place would have resulted in dramatically higher electricity bills and significantly less reliable service for families, businesses, hospitals, and schools across America. That's important to everyone who has suffered through the storms of this winter or who is looking ahead to triple-digit heat in the coming summer. What we've said all along is that such a complete redesign of the nation's electric grid can be done, but it must be discussed, debated, and passed by the people's representatives, the United States Congress. A major change like the power rule should not and cannot be left in the hands of unelected bureaucrats who have demonstrated more concern about placating the green lobby than keeping Americans working. This move was a blatant attempt to sidestep the legislative process and force through the will of one man, President Obama, who tried to redraw the powers of the EPA in unprecedented ways. The regulations the EPA sought to impose were impossible and unfair, and proposed alternative plans for producing power that are unrealistic. Yesterday, the Supreme Court agreed that rushing through policy like this was a bad idea that could cause irrevocable harm to state economies and the national electric grid, not to mention killing American jobs. I'm proud that along with West Virginia, Texas was able to help lead in this noble effort. Thank you very much.
Thank you very much, General Paxton. Very much am grateful for your leadership in this area.
And thank you.
Okay, so what we're going to do now is we're going to open up to just a couple questions from local and national press, and then we're going to turn it over to some of the legislators and others here in this room today.
The appellate process is likely to push this back probably into 2017 when there'll be a new president, whoever that is. Is that important?
It's very important. First of all, I want to mention to everyone that the next step of this process continues right now, that we are going to be submitting a brief on the merits to the D.C. Circuit Court, I believe on February 19th. There will be oral arguments in Washington, D.C., likely June 2nd and 3rd. And then we expect that the D.C. Circuit will issue a decision sometime later in the summer and the fall. I would imagine that either party that does not win in D.C. is going to go right back up to the U.S. Supreme Court, and that means that this case will be before the High Court sometime in 2017. The critical reason we asked for a stay, though, is because harm was happening right now here in West Virginia, and we believe that there's a very real likelihood of success on the merits. And we know that 5 justices agree with that. But certainly electing a new president is going to be very important because these decisions may fall into his lap. Next question.
The administration has indicated that it will take aggressive steps in other ways. Does that concern you?
Well, I think we're beginning to prove that little old West Virginia, with a very large bipartisan coalition, can fight back. Right now, we've been able to work with a large coalition of states to stop the Waters of the United States rule, one of their top domestic initiatives. We've worked with Texas. Texas has shown great leadership in putting a halt to the immigration policies that this administration has advanced. And of course, we just recently obtained the stay of the president's power plan. If this president tries to advance illegal executive action, the states will be ready to stop him. Next question. I think we're going to go to for questions on the conference call. Curtis is...
Thank you.
Okay, great. Thank you.
If you have a question, please press star then 1 on your touch-tone phone. If you wish to be removed from the queue, please press the pound sign or the hash key. If you're using a speakerphone, you may need to pick up the handset first before pressing the numbers. Once again, if you have a question, please press star then 1 on your touch-tone phone. And our first question comes from Amy Harder from Wall Street Journal. Amy, please go ahead.
Hi, thanks for holding this call, and good morning. As you probably know, the court system has stayed a couple of other key Obama environmental regulations, including one on the waters of the U.S. and also the fracking regulation. And then, of course, this one, which is the biggest one by far. Can you speak a little bit more broadly what you think this says about the administration's environmental and regulatory agenda from your perspective?
Well, we've always said that we believe this administration is trying to run roughshod over the rule of law. And I believe that the courts are sending a message that can't be tolerated. As many people know, we really relied on the Michigan v. EPA case and the UR case because this administration has moved forward with very limited legal authority in a whole area of law with respect to the EPA. If you look at WOTUS, if you look at the Clean Power Plan, you look at fracking, they're being very aggressive, yet it's clear that the case law only provides the EPA with limited authority. So we believe that this administration has really overreached, and it's taken the courts to obviously put a stop to them, put some of these stays in place. We recognize that the stay is not the final say on this matter. This is a case that has to get decided on the merits, but it's much better to be in a position where the court believes you have a likelihood of success than in the other position. Thank
and
you.
Our next question comes from Edward Felter from the Congressional Quarterly. Edward, please go ahead.
Yeah, hi. This is for both of the attorneys general. Can you talk about whether you think states should just stop all planning for compliance, even just meeting with stakeholders or taking background comment while the stay is pending? And do you want EPA to issue some guidance now as to whether they would extend the deadlines if they prevail in the Supreme Court next year? Thanks.
From my perspective, there's no need for the EPA to extend the deadlines. The rule is stayed, and therefore there is no formal legal process to submit the plans. Therefore, I would recommend that states and legislatures across the country do not engage in the costly, burdensome efforts to come into compliance with a rule that will likely be struck down in court. General Paxton, did you want to add something to that?
Well, this is the conference operator. Did you dial *0 for assistance?
General Paxton?
I'm here.
Did you want to add anything to that?
Yeah, I agree with you. We obviously got to stay. The whole point of the stay was to stop us from having to provide any implementation plan, and so we're not moving forward with anything until this case is resolved.
Great. Moderator, next question.
And our next question comes from Alex Golan from Politico. Alex, please go ahead.
Good morning. Thanks for doing this.
Hey, good morning.
I wanted to ask, as you were working previously on your plans, if you had identified any strategies like energy efficiency or anything else that you might still be interested in doing, even though the Clean Power Plan is on hold and maybe struck down.
You know, what I would say is that there should always be thoughtful examination as to how states should become more energy efficient, and state legislatures and Congress will always consider that question. But now that consideration is done without having this terrible sword hanging over people's head. So I think it's always good to talk about various issues and look at ways to move our national energy policy forward. But let's not do so in an environment where people feel that they're going to be forced to come into compliance with an illegal plan. So, I would encourage people to have as many considerations and discussions as possible. But I'd note that if this administration wants to reinstate its power plan, it needs to go back to Congress. You cannot institute such a sweeping, radical transformation of American energy policy without going through the legislative branch. So the administration is going to have to relook at its broader plans.
And Patrick, let me add this. You know, in Texas, we have reduced nitric oxide emissions since 2000 by significant levels. We're also the leader in renewable energy. So states are already proceeding with efforts to have other alternatives, cleaner alternatives, but we don't need the EPA to decide that without our representative government making that decision.
That's exactly right. Moderator,
Thank
next question.
you. And our next question comes from Michael Fisher from Associated Press. Michael, please go ahead.
Thank you. Yes, it's Michael Biesecker with Associated Press. Thanks again for having the call. Just for the record, I was wondering if both AGs could answer whether you believe climate change is real and whether the cause is carbon dioxide in the atmosphere.
Well, let me start out by saying that this initiative has always been about the legality of the president's power plan. I'm a state attorney general. My job is to enforce the rule of law, and that's what I always intend to do. These questions in terms of policy will always arise in Congress and before state legislatures, and I'm going to defer to those policymakers on the decisions they make. But if I see a regulation that I don't believe upholds the rule of law, I will not hesitate to file suit and ensure that this administration lives up to the Constitution the statute and the case law.
And I would agree with that. This case is not about climate change. This is about federal overreach. It's about the power of the president to just change law. It's about our desire to have Congress make those changes. And so just like our other EPA lawsuits and just like our immigration case, this is about following a constitutional process and has nothing to do with climate change.
And our next question comes from Dale Forbes from KPRH Radio News. Dale, please go ahead.
Hi, this question is for Attorney General Paxton. What would have happened in Texas if this had been allowed to stand? What, draw a picture of the future if you hadn't won this decision.
Fortunately, I don't have to worry about that. We never thought this would stand. We thought this was a blatant overreach and a violation of federal law. And so we had no plans to proceed with anything other than fighting this, and that's what we've done. And fortunately, with the help of Morissey and the rest of the AGs, we've been successful.
Moderator, next question.
And our next question comes from John Solano from Washington Examiner. John, please go ahead.
Yeah, thanks for having the call. I was just, the ruling was interesting because it came right when Nazio and Nehruck and Bill Becker's group representing the air agencies in the states were all coming down to have a workshop on compliance hurdles. And I was just wondering if, I think West Virginia is included within that group. A lot of states are, and it doesn't mean that they agree on anything. They just were trying to figure out if we have to move ahead, how do we do that? I was just wondering if given Attorney General what you said about states should not feel like they're legally obligated any longer to pursue planning to meet the September deadline or any other deadline until the merits are ruled upon. Do you think this anything that's discussed at this workshop or that the states should just pack up and go home?
Well, I don't know that it's productive to spend much time talking about a rule that will likely never be upheld. And so obviously I can't control what people across the country do, but if you have a strong sense that this rule will ultimately never see the light of day, then to plan around something that's illegal doesn't seem to be a good use of resources. I would also reinforce that states are not only not required to submit the plans, this entire regulation is frozen. So there is no legal process for submitting a plan, and there is no need to expend precious resources on policies that will never become final.
Thanks.
And our next question comes from Lee Logan from Inside EPA. Lee, please go ahead.
Hi, guys. Thanks for holding the call. I wanted to get a sense of whether you agree with some of the other commenters have mentioned that the Supreme Court's move might have elevated the issue of climate change in the presidential election. And are you concerned at all that might drive out supporters of EPA to elect a candidate that they believe would, continue the policy?
I'm not going to speculate on what the impact will be at the presidential level, but what I will say this. I think every person running for president should be very proud to stand by the rule of law. And also, I think this does really reinforce the importance of having a Supreme Court that is going to look very carefully at decisions. So I don't know, I can't forecast how that will play out in the future, but I will say this. This is a debate worth having. This administration, in so many areas, has run roughshod over the rule of law, whether we're talking about the EPA, whether we're talking about immigration, whether we're talking about health care policy. This administration has time after time after time extended executive actions in a manner that violate the statute and the Constitution. We've been now successful in a number of key areas. So I do think one critical issue going forward will be, where do candidates stand on the rule of law? Will you try to use your executive authority to do things that Congress doesn't allow you to do? Keep in mind that Congress specifically rejected the cap and trade provisions that are included in this regulation back in 2009. So those are good debates to have. Let's have lawful policies pushed in the future. General Paxton, any thoughts?
I don't think I could have answered it any better. I totally agree with your answer.
All right. Moderator, next question. Curtis, how are we doing on time? Moderator?
And our next question comes from Asher Price Austin from American Statesman. Asher, please go ahead.
Hi, thanks very much for hosting this conference call. I appreciate it. Both of you have mentioned immigration a couple of times, and I have a question for Attorney General Paxton. I was wondering whether you're planning to appeal the Dallas judge's decision to reject your bid for an injunction on Syrian refugees. Thank you.
We're in the process of reviewing all of that right now. We've made no decisions about that case at this point.
All right. Moderator?
Thank you.
Next question?
And we have no questions in the queue at this time.
Okay. Any further questions from here?
Bob Aaron from WCHS-TV here in Charleston. This was sort of a cart before the horse type thing, but you remain confident you can beat this thing on its merits.
We are. We've always believed that we're very strong on the merits. And Bob, as you know, we've been at this for a long time. There's a reason why we submitted comments about the illegality of the plan. There's a reason why we filed suit when the rule was in a proposed state. There's a reason why we asked for an immediate stay on October 23rd. We knew that this rule was illegal. And we also knew here in West Virginia that this regulation was helping to cause devastation in our state. It's responsible, at least in part, for job loss and the needless expenditure of many dollars. That's why we've stayed the course and we've kept pressing, and we were able to obtain this very important victory before the U.S. Supreme Court. The fact that the stay was issued shows that there's a real likelihood of success on the merits. So we're going to keep going, and I do have confidence that the U.S. Supreme Court will ultimately come to the right decision again. All right, I think what we're going to do now is we're going to turn it over to some other esteemed guests who are here today. I'd like to first recognize our Senate President, Bill Cole, because I know he's been very involved in so many of the different issues fighting back against the EPA. Mr. President, would you like to... oh, there we go. Thank you, sir. Thank you.
General Morissey, thank you so very much for your hard work. As I know you're aware, I live in the southern part of West Virginia, and President Obama and his EPA's war on coal has been devastating. It has devastated not only families, but entire communities. And not only that, the damage that it's done to our state is phenomenal. I applaud the U.S. Supreme Court's ruling yesterday. General Paxton and Attorney General Patrick Morissey, thank you both for your leadership on fighting for West Virginia, for the West Virginia coal industry, for West Virginia families. What happened yesterday is a great success, and all I can do from the bottom of my heart. Thank you, sir.
Thank you. Appreciate it. And now I'd like to give Speaker Armstead an opportunity to say a few words.
Thank you, General. Just echo what's been said here today. I think that all of us realize that whenever this president has overreached his authority and has put in place these illegal directives without the input of Congress, without the input of the people's elected representatives, that's not only been an attack on the rule of law, as the General has said, but it's an attack on every working West Virginian. And we have seen time and time again warn notices issued, bad news to people throughout our energy industry and throughout our state, and the ripple effect that that's had. And it is so encouraging to have this good news. I am very pleased that the Supreme Court has looked beyond the rhetoric, beyond the agendas that the president has tried to put out there, and as has happened so many times in the history of this country, the checks and balances that we have in our government have worked. And we've seen this government, this court, do what it is intended to do, and that is to be a check on the illegal, unauthorized practice of this administration. So it is incredibly encouraging. I would also echo the thanks to Attorney General Morissey and the coalition that he's built and his staff. I know they have worked tirelessly on this issue. And now, while we have a lot of work to do, and while the impact of this overreach by the Obama administration will take years and years to reverse entirely, this is such an incredibly important step in reversing that trend and making sure that the rule of law is upheld, but also making sure that the men and women of West Virginia can go to work and know that they can have a livelihood, have a future in West Virginia. And we're going to take this as an opportunity, as the General has said, to move forward and make sure we do all we can on the state level to see that happen. So it's a very exciting development. It's a very exciting day, and I think a real reversal in the trend that we've seen throughout the Obama administration.
Thank you, Mr. Speaker. And now I'd like to turn the mic over to Chris Hamilton, if you want to say a few words. I want to note the most important aspect of this victory is that we can stop the bleeding for coal miners and their families. I'm going to reinforce that, and we're going to be spending a lot of time down in southern West Virginia, north central, and we actually have a meeting with a lot of folks in coal miners and their families in the upcoming weeks. So I'd like to hear the perspective of the Coal Association. Thank you.
Thank you, General. I think in addition to the Coal Association, I can also lend a little perspective from the Business and Industry Council on behalf of state businesses and industries, as well as the State Coal Forum Management and Labor. We want to just thank you from the bottom of our hearts for all you've done. I don't think there's any question General Morrissey's been an absolute crusader for West Virginia coal and West Virginia coal miners and West Virginia families since the day he's taken office, and we just are so appreciative of that partnership. You know, our miners, our mining families, they wake up to gloom and doom every single day. And amidst all that negativity, this truly provides a little bit of brightness for their day to day. You know, there's truly an opportunity here to maybe mitigate and stop the free fall that our industry is in as a direct result of these policies coming out of Washington, D.C., and in particular, this federal administration. So it won't mean that miners will return back to work today, but what it will mean is that our coal-fired utilities and our fleet of utilities around the country can immediately reconsider their fuel supplies and their short-term and long-term plans for consuming energy, and perhaps reconsidering the reliance they've always had on West Virginia coal. So it does provide that, that optimism throughout the coal fields. I think it's also appropriate to just point out and make sure that our working miners know that we have a group of elected officials here in Charleston, from our Attorney General to our legislative leader to our legislators, that are working daily on their behalf to try to secure West Virginia coal within the marketplace and to try to make sure that West Virginia mining jobs continue to play a major role within our economy. So on behalf of the Coal Association, the Business and Industry Council, we're just so appreciative, and thank you so much.
Thank you. Appreciate it, sir. And I want to conclude this by once again thanking all the legislators. Hey, Bill, how are you? All the legislators for coming here today and our wonderful team. And I thought I would conclude it on this note. This is all about the coal miners, and who better to hear from to wrap up this press conference than Randy Smith, someone who spent a good part of his life going underground and fighting for working people. Randy, do you want to come up and just say a few words?
Thank you, Mr. Morrissey. I want to say since January 1st, we've lost over 2,000 coal mining jobs, and it seems like every time we pick up the paper, it's an announcement about more layoffs, more warn notices, and this is a breath of fresh air, a glimmer of hope. And I want to thank Mr. Morrissey for the hard work and dedication that he has did with this. From the day he was elected, he's been a friend of coal, and I can't emphasize enough as being a coal miner myself, how much we as coal miners appreciate what you and the other state attorney generals has did. Like you said, this isn't going to be a fix-all cure overnight, but it gives us hope and gives us something to work for and continue to fight for. And on behalf of all coal miners across West Virginia, I want to thank you for your hard work and dedication. And God bless you, and God bless the state of West Virginia.
Sure.
Thank you.
All right, I think that concludes the formal part of our press conference today. General Paxton, do you have any final thoughts?
Yeah, I just want to say this is a great day and a great result for not only West Virginia and Texas, but I think for America, for our Constitution, and for the rule of law. So thank you for your really amazing work, and we'll just keep pushing forward.
Yes, on to the next case. Hey, thank you all for coming today. We look forward to seeing you in the days, weeks, months ahead. And to the press listening, if you have any follow-up questions, we're happy to try to answer them. Thank you all again. Hey, man.